Hello friends, in the series on the income tax cases, today we will discuss a very important case which throws light on the concept that what is the tangible material for reopening a case of the assessee under section 148 and what actually the concept liability means which is there in reopening the case of the assessee under section 148. It has been seen that the department is opening the cases of the assessees under section 148 on the basis of generalized reports where there is no specific involvement of the assessee in those reports, and when there is not even the name of the assessee in those reports or the statement of the entry operator. So whether that reports or statement can be said to be tangible material for reopening the case of the assessee. This issue has been decided by Honorable Delhi High Court in the case of Sanjay Kaul versus Income Tax Officer and others, and this case is reported in 479 ITR at page number 146, and the date of the judgment is 30th May 2025. The facts of the case are very interesting. In the present case, the assessment year involved is 14-15. The assessment of the assessee was completed under section 143 subsection 3, in which the short-term capital loss which was adjusted by the assessee with his other income was accepted. After that, based on the investigation report of the department which was received by the assessing officer, and that investigation report was prepared in consequence of a search on a stock exchange company ESB, where the statement of its director was taken, and he has admitted the name of some companies by saying that these companies were involved in rigging the prices of the shares and booking the bogus penny stock transactions. In that statement, the name of some companies were there, and in the name of those companies there were two companies, IIS and SRK, whose shares were purchased by the assessee and sold by the assessee, and there was short-term capital loss on the sale of those shares. When the case was reopened under section 148, it was the submission of the assessee that the assessing officer do not have the reason to believe to reopen the case on the basis of the material available with the assessing officer, but the assessing officer rejected the objections of the assessee and proceeded with the assessment proceedings. So the assessee chose to file the writ petition on the sole ground that the assessing officer has not reason to believe that the income of the assessee has escaped assessment on the basis of the so-called tangible material by the assessing officer. So in the present petition, the sole issue before the court was that whether these generalized reports, whether these generalized statements where the name of the assessee is not there, where there is no specific involvement of the assessee is established with those reports, can be said to be tangible material. And when there is no such tangible material, there will be no live link between the so-called tangible material and the escapement of the income of the assessee. So when the court heard the matter, the court said that the reasons to believe which has been recorded by the assessing officer talks about some purchase and sale of the shares by the assessee in these two companies. So according to the court, mere purchasing and selling of the shares does not mean that the assessee has entered into some fraudulent activity of curtailing its tax liability. The court said that such information could not be sufficient reason to believe that the income of the assessee has escaped assessment because they lacked specific material, because that report is only generalized information, and the revenue has grossly failed to establish the assessee's specific involvement in these transactions. The court said that the material based on which this report is prepared has not been placed on record till date, and the reason to believe cannot be conflated with reason to suspect in any case. So, the reopening of the assessee of the concluded assessments cannot be done on the basis of the suspicion. Friends, this case is very important because 90% cases under section 148 are just opened on the basis of generalized investigation report and statements. At the end of this video, once again I am repeating the name of the case. The name of the case is Sanjay Kaul versus Income Tax Officer and others, and this case is reported in 479 ITR at page number 146, and the date of the judgment is 30th May 2025. Thank you, friends.